Today's topic of discussion is RTI, that is Right to Information. Origin of RTI. First point, the RTI of citizens was recognized by Justice K. Mathew in State of Uttar Pradesh versus Raj Narayan in the year 1975. Second, in the S.P. Gupta versus Union of India, the Supreme Court held that the freedom of speech and expression includes within its scope RTI in the year 1982. Third, in Mr. Kulwal versus Jaipur Municipal Corporation case in the year 1986, the Supreme Court directed that freedom of speech and expression provided under Article 19 clearly implies right to information. Without information, the freedom of speech and expression cannot be fully used by the citizens. Fourth, the first grassroots campaign for RTI was started by Mazdoor Kisan Shakti Sangathan in Devdungri, Rajasthan in the year 1994. The National Campaign for People's RTI, formed in 1996, formulated the initial draft of RTI law for the government. The Press Council of India drafted an RTI bill in 1996 under the chairmanship of Justice P.B. Sawant. The Institute of Rural Development, Hyderabad, drafted an RTI bill in 1997. In 1997, the Department of Personnel and Training established a working group under the chairmanship of H.D. Shourie to prepare a draft legislation on freedom of information. Fifth, the Freedom of Information Bill was introduced in July 2000 and the Act was repealed in 2002. This Act did not acknowledge the right to information of the people. It provided for appeals only within the government bodies. It barred the jurisdiction of the courts and did not ensure any appeal with any independent body. Sixth, the RTI bill was passed by Parliament on 15th June 2005 and came into force on 12th October 2005. Thus, the RTI Act replaced Freedom of Information Act 2002. The RTI is an Act of Parliament of India which provides rights to all citizens, access to information under public authorities with a view to promote transparency and accountability, which reduces corruption and inefficiency in administration. Right to information is not included as a fundamental right in the Constitution. It protects the fundamental rights to freedom of expression and speech under Article 19(1)(a) and right to life and personal liberty under Article 21, guaranteed by the Constitution. But the Ashwini K. Singh's case in 2020 made it clear that RTI is a fundamental right. Seventh, the RTI Amendment Bill 2019 sought to amend sections 13, 16 and 27 of the RTI Act. The RTI Act amended was passed on 25th July 2019, which modified the terms and conditions of service of the CIC and ICs at the center and the states. Objectives of RTI. The objectives of RTI are as follows. First, to empower the citizens to seek information from the government. Second, to promote transparency and accountability in the working of the government. Third, to contain corruption. Fourth, to ensure that the government is more accountable to the citizens. Fifth, to uphold the spirit of democracy. Thus, the RTI enables the country to achieve good governance. Exempted departments from RTI. The various departments which are exempted from the RTI Act are listed in Schedule 2 of the Act. They are as follows. First, Intelligence Bureau. Second, Research and Analysis Wing, including Aviation Research Center. Third, Directorate of Revenue Intelligence. Fourth, Central Economic Intelligence Bureau. Fifth, Directorate of Enforcement. Sixth, Narcotics Control Bureau. Seventh, Special Frontier Force. Eighth, Border Security Force. Ninth, Central Reserve Police Force. 10th, Indo-Tibetan Border Police. 11th, Central Industrial Security Force. 12th, National Security Guard. 13th, Assam Rifles. 14th, Shashastra Seema Bal. 15th, Directorate General of Income Tax Investigation. 16, National Technical Research Organization. 17, Financial Intelligence Unit. 18, Special Protection Group. 19, Defense Research and Development Organization. 20, Border Roads Organization. 21, National Security Council Secretariat. Exempted information from RTI. There are specific instances whereby RTI information cannot be furnished. They are as follows. First, would affect national security, sovereignty, strategic, economic and scientific interest. Second, relates to trade secrets or intellectual property. Information which might affect the competitive position of a third party. Third, relates to information under fiduciary relationship. Fourth, relates to foreign government information. Fifth, would affect the life and physical safety of any person. Sixth, would affect the process of an investigation. Seventh, relates to cabinet papers. Eighth, relates to personal information without any public interest. Under RTI Act, first one, meaning of information. The word information can be in the form of records, documents, memos, emails, opinions, advices, press releases, circulars, orders, logbooks, contracts, reports, papers, samples, models, data stored in any electronic form. It also includes information relating to any private body which can be assessed by public authority under any law for the time being in force. Second, meaning of public authority. A public authority is any authority or body established or constituted by or under the Constitution or by any other law made by the Parliament or state legislature or by notification issued or order made by the central or state government. The body is owned, controlled or financed by the central or state government, and non-government organizations financed by the central or state government constitute public authority. Third, procedure for application of information. Any Indian citizen can submit request for information under the RTI Act from any public authority along with an application and a demand draft or a banker's check or Indian postal order of ₹10 as fee for seeking information. The payment of fee can be made by cash against proper receipt. If the applicant is below poverty line, he is not required to pay any fee but should submit a proof to support his claim. Fourth, the Public Information Officer, that is PIO. Public authorities have to appoint its officers as Public Information Officer, PIO. When a department gets an RTI request, it's the responsibility of the PIO to furnish the information to the applicant within 30 days. In case the application is sent to the Assistant Public Information Officer, that is APIO, or it is sent to a wrong public authority, 5 days can be added to 30 days period. If it is a matter of life and liberty, the information has to be provided within 48 hours by PIO. In situations where government records are misplaced or missing, or there is need for coordination with other departments to provide information, it may take more than 30 days. In such cases, the PIO has to intimate the applicant about the delay with the reasons. A. First appeal. If the applicant does not receive information within the prescribed time or is not satisfied with the information given to him, the applicant can appeal to the first appellate authority, who is an officer senior in rank to the PIO. Such an appeal should be filed within a period of 30 days from the date on which the limit of 30 days of supply of information is expired, or from the date on which the information of the PIO is received. The appellate authority should dispose of the appeal within a period of 30 days or 45 days of the receipt of the appeal. B. Second appeal. If the first appellate authority does not pass an order within the prescribed period, or if the applicant is not satisfied with the order of the first appellate authority, he can make a second appeal with Central Information Commission, that is CIC, within 90 days from the date on which the decision was made by the first appellate authority. C. Penalty. The CIC receives complaints from any person: A. Not being able to submit an information request because PIO was not appointed. B. refused information that was requested. C. Not received response within the specified time limit. D. Thinks the fee charged are unreasonable. E. Believes information given is incorrect, incomplete, or false or misleading. F. Any other matter relating to obtaining information under this law. First one, the CIC can impose a penalty of rupees 250 per day, but the total penalty cannot exceed rupees 25,000. Second, the CIC can recommend disciplinary action against the PIO under the applicable service rules. To note, before a penalty is imposed, the official will be given an opportunity to be heard. Not only the PIO, but other officers whose assistance was sought can be penalized for non-compliance of their duty. An applicant can submit only 3 RTI applications in a year to seek information as per the Supreme Court order. Fifth, 2 major bodies. The RTI is governed by 2 major bodies. First, CIC, Chief Information Commissioner, who heads all the central departments and ministries with their own public information officers. CIC are directly under the President. Second, SIC, State Public Information Officers, head over all the state departments and ministries. The SPIO office is directly under State Governor. Sixth, features of Central Information Commission. They are independent bodies. The CIC has no jurisdiction over SIC. They are not constitutional body but a statutory body. A. Composition of CIC. First point, CIC is constituted by the central government through a gazette notification. Second, the commission consists of 1 Chief Information Commissioner and not more than 10 Information Commissioners. Second, appointment. The CIC and IC are appointed by the President on the recommendation of a committee consisting of the Prime Minister, who is the chairperson of the committee, the leader of the opposition in the Lok Sabha, and 1 Union Cabinet Minister nominated by the Prime Minister. The CIC is not eligible for reappointment. IC is eligible for appointment as CIC but is not eligible for reappointment as IC. Third, oath of office. The oath of office is administered by the President according to the form set out in the first schedule. Fourth, qualifications of CIC and IC. The qualifications are as follows. The CIC and IC must be persons of eminence in public life with wide knowledge and experience in law, science and technology, social service, management, journalism, mass media, or administration and governance. Second, CIC or IC should not be a member of parliament or state legislature of any state or UT, or hold any office of profit, or connected with any political party, or carrying on any business, or pursuing any profession. Fifth, tenure. The CIC and IC will hold office for a term as prescribed by the central government or till the age of 65 years, whichever is earlier. The CIC and IC will hold office for a term of 3 years as per the new RTI rules issued by the central government. Salary. The CIC and IC will receive a salary of rupees 2,50,000 and 2,25,000 per month. As per the RTI Amendment Act 2019, the central government will notify the quantum of salary through rules. Seventh, powers and functions of CIC. The powers and functions of CIC are as follows. First, the CIC has the duty to receive complaints from any person. A. Who has not been able to submit an information request because PIO was not appointed. B. Who has been refused information that was requested. C. Who has not received response within the specified time limits. D. Who thinks the fees charged are unreasonable. E. Who believes information given is incomplete or false or misleading. F. Any other matter relating to obtaining information under this law. Second, the CIC has the power to initiate an inquiry if there are reasonable grounds. Third, the CIC, while inquiring into any matter, have the same powers as are vested in a civil court while trying a suit. The powers are: A. Summoning and enforcing the attendance of persons and compelling them to give oral or written evidence on oath and to produce the documents or things. B. Requiring the discovery and inspection of documents. C. Receiving evidence on affidavit. D. Requestioning public records or copies from any court or office. E. Issuing summons for examination of witnesses and documents. F. Any other matter which may be prescribed. Fourth, the CIC, while inquiring any complaint, can examine any record which is under the control of public authority, and no record can be withheld on any ground. Fifth, the decision of the CIC is binding, and the CIC has the power to secure compliance of its decision by the public authority, which are as follows. A. By providing access to information in a particular form. B. By appointing Central Public Information Officer or State Public Information Officer as the case may be. C. By publishing certain information or categories of information. D. By making necessary changes to its practices in relation to the maintenance, management, and destruction of records. E. by enhancing the provision of training on the right to information for its officials. F. By providing an annual report from the public authorities. G. By requiring the public authority to compensate the applicant for any loss or other detriment suffered. H. By imposing penalties under this Act. I. By rejecting the application. Sixth, the CIC gives notice of its decision as well as right to appeal to the applicant and the public authority. Seventh, the CIC decides the appeal in accordance with procedure prescribed. The implementation report is as follows. First point, each ministry has to compile reports from its public authorities within its jurisdiction and send them to CIC. Second, each report will contain A. The number of requests made to each public authority. B. The number of applicants who were not allowed access to the document. C. The number of appeals referred to the CIC for review, the nature and outcome of the appeals. D. The amount of charges collected by each public authority. E. The effort put by public authorities to administer and implement the spirit of the law. F. Recommendation for reform not only to develop, improve and modernize particular public authorities, but also reforms in law to keep the right to access information operational. Third, the report prepared by each ministry is sent to CIC, and the CIC will send an annual report to the central government on the implementation of the provisions of this law at the end of the year. Fourth, the central government will table the CIC report before Parliament. Pros of RTI. The merits are as follows. First, transparency. The RTI empowered the people to question, review, examine, and assess government decisions to ensure that there is good governance. Second, reduction of corruption. As information is accessible, corruption has taken a down curve. Third, participative democracy. RTI makes the citizen a partner in the decision-making process, thus establishing citizen-centric governance. Fourth, accountability. RTI opens up government's records to public scrutiny, thus making government accountable. Fifth, information available. Information was the property of the ruling side, and high secrecy was maintained. But the RTI Act gave accessibility of information on issues like land, social security benefits, civic infrastructure, etc. Sixth, scams in open. All scams came out in open from 2G to Colgate due to RTI Act. Cons of RTI. The demerits are as follows. First, no authority. The RTI Act do not give adequate authority to the Information Commissioner to enforce their decisions. Second, burden. RTI is filed by many applicants on the same subject. This increases the burden of work on PIO. Third, wrong information due to overburdened applications seeking information. Sometimes wrong information is given out. Fourth, abuse of information. Sometimes frivolous RTI applications are put. The information obtained is used for vengeance or blackmailing government authorities. Fifth, appointment of PIO. In some departments of the government, information officers are not appointed, and so people are unable to get information. On the other hand, departments appoint more than necessary information officers, which also make it difficult to secure information. The RTI Act is a strong tool to uphold the spirit of democracy. The need of the hour is that the RTI Act should be implemented to ensure that the objectives of the Act are fulfilled. By enacting the RTI Act, India has taken an important step to fight corruption and provide good services to the people. Any attempt to dilute the RTI Act will not only quell its success but also faith and trust of the people.